Hello and good morning, everyone. A very warm welcome to you all and welcome to EBC Learning and to this interesting webinar on a very important case, Jarnail Singh versus Lachhmi Narain Gupta on reservation in promotion. Our speaker today is Dr. Charu Mathur. Dr. Charu here needs no introduction. She has already conducted 2 most successful AOR courses at EBC Learning. Dr. Mathur has a rich and diverse expertise in corporate, commercial, civil, criminal, and constitutional law matters. She is an advocate on record, Supreme Court of India. She has represented parties, including cricketing bodies and educational institutions like IIT Jodhpur, NLU Jodhpur, and other private engineering and medicine colleges of Gujarat and Orissa. She's also a passionate academician and a dear colleague of ours and has authored various courses at EBC Learning. She has done courses on corporate law, various modules on insolvency and negotiable and limitation. And also she's been part of the live courses which are happening right now in EBC Learning. Thank you, Dr. Charu, for joining us today. And we at EBC Learning offer both skill-based and foundational courses, which are very much rigorous and comprehensive. We have numerous courses in our portal. The live course, which is currently happening in our upskill diploma in advanced corporate law in collaboration with CII. This is our most extensive live course on corporate law. And also EBC Learning, Bennett University, Mastery Certificate in Advanced Corporate Law. It is an on-campus program. More details on our website. These are a few exceptional courses which are taught by industry experts and professionals. At EBC Learning, we provide both academic and skill-based training, which are very well presented on on-demand, and they're self-paced and instructor-led courses. Let me just take you through the website first. Hold on, and I'll share my screen now with you all. Now, when you go to our website here, you can see numerous courses. These are 3 kinds of courses which we currently are offering. One are the skill-based courses, foundational-based courses, and competitive exams courses. Now, skill-based courses are those who want to enhance their learning in their professional pursuits, and foundational courses are very much rigorous and comprehensive, which want a strong foundation in your particular subject. And all the courses are mentioned here. You just need to click on your right, and whatever course you want to learn, you can. So we have got instructor-led courses, and we have got self-paced, which are 15 number, various paths, competitive examinations, law school courses, which are 37 in number. We have legal skill and practices courses as well. As you can see, filing and insolvency by Dr. Charu Mathur herself. We have competition law. We have transacting mergers and acquisitions. We have practicing mediations, RERA essentials, insolvency essentials, various modules on insolvency essentials. The second module also is out now for you all to learn. And we have consumer protection law, we have contract essentials, we have law and psychology, and corporate law essentials. We have various modules on corporate law, and also a live course which is running right now at EBC Learning. And the most important one, which we are going to start here, and it is the AOR exam course. That is an advocate on record examination course here. You click here and you get all the details. So you can enroll by 15th June. And the start date is 15th June. And in addition here, basically when you sign up and you get extensive learning, and which practically it will include everything. Now, more on this course and more on today's case, I would just like to hand it over to Dr. Charu. Dr. Charu, over to you, and thank you very much, everyone.
Thank you, Dr. Achal, for that comprehensive introduction and a very kind introduction. And it is very useful to go through the website, where we have, with a lot of pain and a lot of love, created almost 60+ courses. Now, to start with, today I'm going to discuss with you a very important course. As a service law lawyer, as a person who looks after education law matters, I think this is one judgment which you should be well aware of. Once you read this judgment, which is authored by Justice Narayan, you will realize that it covers, like all his judgment, a bit of history and how it came into being. Now I'll just share my screen. I will be sharing the PPT with you. I hope my screen is visible.
Yes, Dr. Charu. It's
so, okay, right. So the case that we are going to discuss, it is called Jarnail Singh versus Lachhmi Narain Gupta. It is a decision which is given in 2018. It was a decision given on a reference made by, because of two judgments. They said at which judgment to follow, what is the correct law laid down in the M. Nagaraja, or should M. Nagaraj should need the revisit. Now, as you know, if you look at our constitution and if you look at our constitutional scheme, so there is a very strong principle of equality given as a under part 3, which is your fundamental rights. So there is a concept of equality which is given in our constitution. Now, to take it to bring the entire society at the level playing field, you have to raise the standards of the others so that entire society is at par. So, there is something known as affirmative action, and for centuries, there has been long social and economic discrimination which is there. So, Article 14 and 15, which provides you equal protection of law and non-discrimination. Then you have Article 16 of the Constitution, which expressly provides for equality in public services, in the public jobs. And then you have Article 16, Clause 4, which expressly allows the state, that is the governments, to undertake affirmative action for socially and educational backward class in the government employment. So this is a specific provision which is provided. Now, when the constituency, whenever I say, when we look at any of the concepts of law, it is very important that we have to keep into consideration this, what was the socio-economic situation at that point of a time, right? So when India got independence in 1947, we had the largest population which was illiterate. We had a population which was socially and economically very backward, and it was a miracle that we had gone with the universal franchise when even the most advanced countries, they didn't had, or they took a lot of revolution, I'll say, to start with the adult suffrage. So in a way, we had a head start to bring our country back to the glory that it deserves. So even before, see, if you must also know that the first the government that was there, right, when the constitution was adopted in 1950, India got independence in 1947, and in between you didn't had a democratically selected government, but whatever was the constituent assembly, that also became the governing body until you had your first election. Now, meanwhile, what happened that in the Supreme Court, there was a judgment which had come that was by the name of State of Madras versus Champakam Doyavajan. Now, in this, the Supreme Court held that it was regarding whether a communal reservation can be given to the various categories of the person, whether it is valid or not in the education institution. So Supreme Court held that Article 16(4) was an exception to the principles of equality which are found under Article 14, 15, and 16. And consequentially, at that point of a time, I'm talking about 1951, there was no Article 15, subclause 4, which allowed the reservation in the educational institution. And any such reservations violated the principles of equality, and hence it was held in Champakam Doyavajan to be unconstitutional. Of course, later Parliament amended the constitution by inserting Article 15, subclause 4. Now, despite the fact, I'm just giving you the background fact before I come back to the Jarnail Singh case. Now, despite of all this, Article 15, subclause 4 of the Supreme Court, it continued to treat affirmative action as an exception to the general principles of equality. Then came a very, very important decision by Honorable Justice P.B. Gajendra Gatkar in case of Balaji versus State of Mysore, where they sought a reservation of around 68% of the seats in engineering and medical colleges for scheduled caste, scheduled tribes, and the backward class candidates. Now, Justice Gajendra Gatkar struck down this provision. So, and why I am telling you this, because you hear about 50% reservation limit and why this came. So the court imposed two restrictions on the reservation in M.R. Balaji's case, which is authored by Justice Rajendra Gatkar. It is a 5-judge bench judgment of the Constitution bench. It said that in line with the exception argument, in the ceiling of 50% would apply. And secondly, caste alone could not be the basis for favored treatment. So you have to remember that 50% and reservation that you are getting, you have to trace it back to the Balaji, because he said that if you are giving reservation, 70% reservation to the reserved class, that means you are depriving the others of the benefit of the reservation, of competitive exam and merit. Likewise, there was the judgment of Chitralekha versus State of Mysore, in which the court ruled that the use of caste as a measure of eligibility was not mandatory, which would enable the government for using more flexible definition. Now, between all this that was happening, there was already one backward commission by Kaka Kelkar, but it gave in a very vague manner, and ultimately they had to constitute a second backward commission, which was by Mandal Commission, right? So thereafter, see, first you have to remember is Champakam Dorai Raju. You have to remember State of Madras versus Champakam Dorai Rajan. Second, you need to remember is Balaji, M.R. Balaji versus State of Mysore. Thereafter, you have to remember Chitralekha versus State of Mysore, right? And thereafter came the case called Rajendra versus State of Madras, in which the court ruled that caste could be used as an exclusive eligibility criteria only if it can show that entire caste was educationally and socially backward. But it was the watershed moment, according to me, for reservation is the decision of Supreme Court in case of N.M. Thomas. This was in 75. Soon after the basic structure doctrine was propounded in Keshwanand Bharti, it has come, it was, earlier also in one of the cases it was discussed, but generally we take it was done in the Keshwanand Bharti's case. And in this case of N.M. Thomas, it is a decision by 7-judge bench. It held that government order which grants provisional promotion of members of SC and ST who did not have requisite qualification to be eligible for such promotion, along with 2 years grace period for them to gain such qualification, was challenged on the ground that it was not covered by Article 16(4). Now, court rejected this argument, and court held, and it is very important to note that court held in N.M. Thomas that Article 16(4), when properly understood, was not an exception to Article 16(1), but it is a facet of Article 16(1). Then there was a concurring decision by Justice K.K. Mathew and Justice Krishna Iyer, and they invoked the directive principles of state policy to substantiate this claim. So the court started from N.M. Thomas, started treating the constitutional baseline as the formal, literal conception of equality with affirmative action as the exception to treating the substantive equality as integral part of the code. Now, after making this advancement, and in between you have to read one more dissenting opinion by Justice Subba Rao, the great dissenter, in T. Devadasan case, and he has adopted such a view. Now, this conceptual advancement which was made in N.M. Thomas, it was finally applied by 9-judge bench in Indra Swani versus Union of India. So in the Indraswamy judgment, the court has to consider whether the issue of affirmative action in the wake of government decision to implement second backward commission, that is a Mandal Commission's recommendation for reservation to other backward class. So in this case, it was held that unfilled places could be carried forward for 3 years, and the program was to be applied to the promotion as well as for the initial recruits, which included all institutions receiving government funds. And in Indraswamy, again, the court, it reaffirmed the 50% ceiling, and it held that it will not apply to the promotion. In Indraswamy case, the court also held that affirmative action on promotion, it can continue for a period of 5 years. So, in Indraswamy, when they had to determine the eligibility, the court rejected the use of caste as the only basis for eligibility, holding that despite the literal language of 16(4), social to a lesser degree, educational backwardness, it must be considered. Now, I'll again share my screen with you. I would just like to take you through these Article 16 as a whole. So in Article 16, it was 16, 1, 2, 3, 4. Later, these parts were added. So Article 16, it says that there shall be equality of opportunity for all citizens in the matter stating to the employment of or appointment to any office under the state. Then they said that no citizen will be discriminated only on the grounds of religion, race, caste, etc. Then this says, the third clause, it says that nothing in this article shall prevent Parliament from making a law prescribing in regard to the class of classes. So it provides for reservation then and there. And finally, the fourth clause said that nothing in this article shall prevent state from making any provisions for the reservation of appointments of posts in favor of the backward class of citizens, which in the opinion of the state is not adequately represented in the services under the state. So from here, I would like you to note 2 words. It talks about reservation of appointments, and then it talks about when they are not adequately represented. Now, as I have just told you that what Indraswamy did, that they will give you appointments for promotion, there was no, but if there has to be given, then it will be max for 5 years. Now, to overcome this, the government, it inserted this Article 16, 4A. It was inserted by 77th Amendment. And it provided that nothing in this article shall prevent the state from making any provisions for reservations in the matter of promotion. With consequential seniority was also added to any class or classes of post in the service under the state in favor of the scheduled caste and scheduled tribes, which in the opinion of the state are not adequately represented under the services of the state. So this was the second part was added. That consequential seniority part was added via 85th Amendment. Before that, 4B was added, and it provided that nothing in this article shall prevent the state from considering any unfilled vacancies of the year which reserve been filed up that year according to any provisions for reservation made under clause 4 or 4A as separate class of vacancies. So this comes the carry forward thing. Right? And then you have got 5 and 6, with which we are not really concerned at this stage. 6 talks about economic reservation for EWS 10%, which is also under the challenge before the Supreme Court. And I am involved in one of the matters where we are challenging the criteria which is adopted to find whether the person comes under the EWS layer or not. Now, just for your understanding, this is a quick timeline that I have prepared. In this 1992, we are just focusing only on Jarnail Singh from now on. So I am not taking you through the Champak Dorai region or N.M. Thomas and others, but I'm just, or Balaji, but I'm just focusing right now only on Jarnail Singh. That was for the background that I had to give you. Now, in 1992, Indra Swani's 9-judge judgment came and they said that Article 16(4) is not applicable to appointments but not to promotion. Thereafter, you have the 77th Amendment, which I have just told you that it added Rule 16(4), Article 16(4)(a) to nullify Indra Swani's judgment, and which allows the state to provide reservations to SC/ST in the matter of promotion as long as the state believes that they are not adequately represented in services. So we have to look at the criteria. How will you determine whether they are adequately represented or not? Thereafter came catch-up rule. It provided that catch-up rule was introduced as 16(4)(a) brought in anomaly. Juniors become seniors. So Supreme Court in Virpal Singh and Ajit Singh had to set it right by this judgment. So what happened was that the reserved class category people, they were getting accelerated promotion because of the 77th Amendment. And as Justice Rajendra said in M.R. Balaji, that if you give reservation to the 70% of the population or to the reserved category, then you are undermining the merit, you are undermining the proportionality, you are undermining the reservation which is to be provided to the various classes. Thereafter, you had 81st Amendment, which followed the carry forward rule, seamless promotion to be reserved. It allows to breach 50%. Thereafter, you have further amendment which added a proviso to Article 335, which provides for relaxation of marks. This was done to undo S. Vinod Kumar's judgment of the Supreme Court. So it provided for lowering of marks in case of the reserved category. Thereafter, in 2001, you had a consequential seniority amendment which was done to undo Ajit Singh and Virpal Singh's judgment. Now, what happened, and it is very important for us as far as this case is concerned, that in 2006 came the decision of M. Nagarajan, where the constitutional validity of Amendment 77, 81, 82, and 85th Amendment was challenged. So Supreme Court upheld Nagaraj, and it held that the reservations and the promotion are to be valid. The state has to meet 3 compelling requirements. Please note that in this M. Nagaraj case, the court categorically held that to provide for the reservation and promotion, state has to meet 3 conditions. What are these 6 conditions? First, the state has to demonstrate the backwardness of the SC/ST. It has to prove that the SC/ST is inadequately represented in the relevant public employment, and it has to maintain the overall efficiency of administration. So these are the 3 conditions. If they are provided, then state can provide reservation in the promotions as well, and not just the initial appointment. So these are, you have to demonstrate the backwardness of the SC/ST. You have to prove that SC/ST is inadequately represented in relevant public employment, and you have to maintain the overall efficiency of the administration. Now, as a consequence of Nagaraj judgment, many high courts, they started striking down various statutes which provides reservation. So one such case was of State of Tripura versus Jayanta Chakravarti, where various states and union challenged Nagaraj and said that due to the owing of these impossible situations, the government is not able to fulfill further reservations, right? It cannot fulfill its agenda of providing affirmative action. So in 2018, there was a reference which was done, so which was to held whether the Jarnail Singh, Nagaraj was also a 5-judge bench judgment, and so it said that Nagaraj needs a reconsideration, and then they said in the Jarnail Singh that please make a reference to the 7th layer as to whether the creamy layer can be applied to SC/ST and can be struck down for further backwardness. Thereafter, in 2019, you had a BK Pavitra 2 judgment, which introduces the new inclusive definition of administrative efficiency under Article 335 of the Constitution. In this, Karnataka Act was challenged, and despite Nagaraj, the BK Pavitrata said that the state has failed to apply the creamy layer test which was introduced. And in this case, the court said that what you have to do is to look at a cadre, at a group and not cadre. Then, as recently as in 2022, there is a decision of Jarnail Singh. This is after reference, which is a decision by Justice Ellen Rao, Sanjeev Khanna, and Justice BK Gawai, where Nagaraj's perspective was taken into consideration, and court held that what BK Pavitra 2 held, that group is not proper, but it has to be cadre. So the court has reasoned that test can only be applied at the stage of the reservation in promotion, but not at consequential seniority. Now, I know this is quite a mouthful, but now I am going to focus on what is our main task at hand. So our main task at hand is to discuss the Jarnail Singh versus Lachhmi Narain Gupta's judgment. Now, this decision was given by a 5-judge bench, which was headed by then Chief Justice Deepak Mishra. Other members of the bench were Justice Kurian, Justice Nariman, Justice Kaul, and Justice Indu Malhotra. This judgment is a unanimous judgment, and it was authored by Justice Narayan. Now, how does the matter reach to the constitutional bench? So there were 2 references. One was by the 2-judge bench in case of State of Tripura versus Jayanta Chakrabarti, and another was a 3-bench judge of a second reference from the state of Maharashtra. It was called State of Maharashtra versus Vijaya Ghobre, and it referred to the correctness of the decision of M. Nagaraj, and hence the Jarnail Singh was before constitutional bench of 5 judges, where they have to discuss whether M. Nagaraj needs a reconsideration, and hence whether it needs, and as a consequence of that, should it go to the 7-judge bench. Now, what all was entailed in this judgment was interpretation of Articles 16, 4A and 4B, and Articles 335, 341 and 342 of the Constitution. Now I have just shown you Article 16, and I will just want to focus with you on Article 16, 4A and 4B. I would like you to read with me. Article 16 provides for equality of opportunity in matters of public employment. So you need to remember that this is equality's relation to public employment, and it states that nothing in this article shall prevent the state from making any provisions for reservations in matters of promotion with consequential seniority to any class or classes of post. Very important thing that you need to understand is that it provides for reservations in matters of promotion with consequential seniority to any class or classes of post. Very important thing you need to understand that it provides for any class or classes of post in the services under the state in favor of scheduled castes and scheduled tribes, which in the opinion of the states are not adequately represented in the services under the state. Right? So I have just put these things in bold so that you know that it provides that nothing in this article shall prevent. So it allows the states to make reservation and promotion with consequential seniority. Where does it allow? It allows to any class or classes of post in service where SC, ST are in the opinion of the state. So there has to be a satisfaction of the state to say that they are not adequately represented in the services under the state. Thereafter, we move to 4B. Article 16, 4B provides that nothing in this article shall prevent the state from considering any unfilled vacancies of a year which are reserved for being filled up for that year in accordance with any provisions for reservation made under clause 4 or 4A as a separate class of vacancies to be filled up in any succeeding years or years, and such class of vacancies shall not be considered together with the vacancies of the years in which they were to be filled up for determining the ceiling of 50% reservation for total number of the seats. So what it essentially said that if there is some unfilled vacancies of a year, then they get carried forward, but they don't go back to the general pool or to others, but they are carried forward, and that carried forward vacancies are not to be considered together with the vacancies of the years in which they are being filled up for determining the ceiling of 50% reservation on total number of vacancies of that year. Before I dwell it further, I would just like to take you to the articles which are under challenge. Another article under challenge, whose provision we had to interpret, was Article 335. What does 335 provides for? It provides for claims of the scheduled caste and scheduled tribes to services and posts. It provides that the claims of, remember, the claims of members of SC/ST shall be taken into consideration consistently with the maintenance of efficiency of administration in making the appointments to the service and post in connection with the affairs of union and state. The amendment added this proviso. This proviso was added by the amendment, and it provided that nothing in this article shall prevent in making of any provision in favor of the members of scheduled caste and scheduled tribes for relaxation in qualifying marks in examination or lowering the standards of evaluation for reservation in matters of promotion in any class or classes of services or posts in connection with the affairs of union or state. So this it provides for relaxation, but it has to be in the favor of SC and ST in terms of qualifying exam marks in the examination, or even lowering the standards of marks for reservations in the matter of promotion to any class or classes of services or posts in connection with the affairs of union. Thereafter, we will quickly look at two lists which are provided called presidential list. Article 341 provides as Article 341 is your provision for scheduled caste, and Article 342 is for scheduled tribe. Article 341 provides that president, who can do this? The president may, with respect to any states or union territory, and where it is a state, public notification specify the caste, race, or tribe, or parts of a group within the caste, race, or tribe, which shall, for the purpose of this constitution, be deemed to be scheduled caste in relation to that state or union territory as the case may be. Parliament may by law include in or exclude from the list of scheduled caste specified in the notification issued under the clause 1 any caste, race, or tribe, or part or a group within any caste, race, or tribe, but save as aforesaid, a notification issued under the said clause shall not be varied by any subsequent notification. So what Article 341 says, it gives you the list which is to be who issues this. It is to be done by the president in consultation with the governor if it is for the state list, to publicly specify the caste. So here what is it giving? It is identifying that these are the people who belongs to scheduled tribe. Likewise, you have Article 342, which provides the same for scheduled tribes. Now with this, let us move forward. So what was challenged under Nagaraj, what was challenged under Jarnail Singh was M. Nagaraj. In this case, various states have challenged M. Nagaraj, maintaining that it has made unjustly difficult to grant reservations in provisions. They demanded that the review of the three conditions or three controlling conditions of Nagaraj. Nagaraj provides that prior to granting reservation in promotion to SC or ST in public employment, state must demonstrate current backwardness of the SC/ST. So what it says is of the current backwardness, it does not talk about the historical backwardness. It requires that it has to be inadequately represented expression of SC or ST in the relevant sector, and the reservation will maintain the administrative efficiency. Now, what does M. Nagaraj say? We have been saying that Nagaraj is challenged, but what does M. Nagaraj say? So Nagaraj has laid down two tests or twin tests, as we say. Now you all know that basic structure doctrine was has expressly been recognized under Keshwanand Bharti, and Keshwanand Bharti says that you can amend the constitution. Parliament has that power to amend the constitution, provided that the basic structure remains intact. You don't distort it to such an extent that you don't recognize what it is. So accordingly, Nagaraj, it put on two tests. One test is called width test and another test is known as identity test. So what is the width test? Width test is a test to ascertain the width of the effect any amendment might have on the constitution. The width of effect decides the legitimate scope, that is the width of the amending power, and also contemplates all the probable ramification of an amendment to see if the basic structure of the constitution is under threat. So width test is that how much you are amending the constitution and what is its consequence. Does it distort that its basic structure is not remain, or fine, you can amend it, but the basic structure remains that. So it has to pass the width test, and second is identity test. So Nagaraj's second test was identity test, and identity test said that where after the amendment, whether the identity of the constitution remains the same. So width test said that what is the legitimate scope of amending the powers and what are the probable ramifications of that amendment to see whether it is going to disrupt the basic structure or let it retain. And identity test says that whether the amendment is such, whether it has let the constitution retain its basic identity or it has distorted. Now, when I talk to you about basic structure, then what is the basic structure of the constitution of India? So federalism is one of the basic structure, judicial review, independence of judiciary, separation of power. So these are some of the examples which are given. So this is something which gives you the skeleton, the basic structure of the constitution. If this is distorted, then that amendment, then that constitutional amendment has to be struck down. Now let us look at various contentions which were raised by various parties for revisiting Nagaraj. Now, Union of India and various states, they had asked to revisit M. Nagaraj. The charge for the union was led by the learned Attorney General K.K. Venugopal. And when I talk about Mr. Venugopal, you must know that our constitutional foundations, whether it is that the basic judgment of A.K. Gopalan, it is something which has been done by his father, the great M.K. Nambiar. So when Mr. Venugopal, he himself has done so many matters and he is an authority. I am too small a person to say anything about him. He said that he led the charge on behalf of the union, and he said that this is a judgment which required revisitation. And he pointed out there are various points, but these are the 2 points which according to Mr. Venugopal, the learned AG, that it needs to be revisited. First was when Nagaraja states that state has to collect quantifiable data showing backwardness, such observation would be contrary to the 9-judge bench decision in Indraswamy. The court held that the presumption is that if there is somebody who is in the presidential list of Article 341 and 342 is most backward. So he said that there is this presumption that if somebody is in that list, then he is most backward. There is no need to collect any quantifiable data. And Nagraj says that you have to do that. So this is a bad law. This is contrary to Indraswamy. And hence it is important that a 5-judge judgment of Nagraj needs to be revisited. Second thing he said that the second thing which he said, his contention was that the creamy layer concept has not been applied in Indraswamy 1 to SC and ST, and Nagraj has misread Indraswamy to apply this concept of scheduled caste to scheduled tribe. So his contention was you cannot apply the concept of creamy layer to SC and ST. It can be applied to OBCs but not to SC and ST. So learned AG said that once the scheduled castes and scheduled tribes, they have been set out in the presidential list, they are deemed to be scheduled castes and scheduled tribes, and this list cannot be altered by anybody except Parliament under Article 341 and 342. So you will see, you will recall that when I read you Article 341, that it is the president who notifies them, it is the president who says that this person will come under this list. Then AG further said that Nagraj does not indicate any test for determining adequacy of representation in services. So his contention was, you said that they must be adequately represented, you have to demonstrate, but you don't provide any test as to how to do it. And he said on that count also it should fall. And as always, he came out with a suggestion, and he suggested that it is important that we lay down the test be the test of proportion of SC/ST to the population of India at all stages of promotion. So he said that if there are 40%, so you apply 40%. If there are 20%, you apply 20% reservation. So this is the test of proportion which he suggested. He also suggested that the roster system which is provided under R.K. Sabharwal can be utilized. Now, if you practice service law, you need to read R.K. Sabharwal also. It is a very important decision that you need to know. Right now, I'll come back. Thereafter, from the petitioner's side, Mrs. Indra Jaising also raised few contention. And she said that Nagaraj need to be revisited on the ground that Articles 16.4 and 4b, they do not flow from Article 16.4, but instead they flow from the very Article 14, which is the right to equality, and Article 16.1 of the Constitution. Then she raised the contention then that the claims of SC and ST are based on the reading of Article 14, 15, 16, 16.4a, 16.4b, and 335 of the Constitution. She said that any classification within an SC/ST was not permissible. Why? Because it was so held in case of Indraswamy 1 and in case of Chennai. She also contended that Nagaraj would have effect of amending the presidential order relating to SC/ST, which would be violative of Article 341 and 342, and it is only the Parliament who can do so. So she said that if you read Nagaraj, it would have an effect as if you are amending the presidential order relating to SC/ST, and this is not in the court jurisdiction. It is only the parliament who can do so. So, and finally, she said that the exercise of reading down a constitutional amendment to make it valid conducted in Nagaraj is constitutionally impermissible. So she said that if there is any constitutional amendment which has to be read down, so it is not permissible. So either you upheld or you say that it is, or you upheld or you declare it to be ultra virus. And then there was contention which was raised on behalf of State of Tripura, and it said that apart from what learned AG Mr. Venugopal and what Ms. Jaising said, it was added on behalf of State of Tripura that Nagaraj is bad because Nagaraj, a 2006 decision, did not take into consideration 2005 decision of Chennaiya, and both of them, they cannot stand together, which is why it said that Nagaraj is per incurium as it does not refer to the judgment of Chennaiya at all. Now, coming on to the next is contentions which were raised by Nagaraj. Now, when we come to the defense of Nagaraj, this defense was led by legendary Shanti Bhushan. Shri Shanti Bhushan defended Nagaraj, and he said what Nagaraj speaks about backwardness of the class. When he talks about class, he does not talk about SC/ST at all. But what Nagaraj talks about is class of post. So you will recall when we were reading Article 16(4)(a) and 4(b), I highlighted class of post there. So that was the reason. Secondly, he said that it is clear that backwardness in relation to the class of post spoken of would require quantifiable data, and it is in this context that the associate observation has been made. And then he referred to Keshav Mills, which held at constitutional bench judgment. Remember, Nagaraj was also a uniform judgment, which held that constitutional bench which stood the test of time ought not to be revisited. So let me just explain you the defense which was raised by Mr. Shanti Bhushan. He said that when you are talking about the class of backwardness, you are not talking about class of backwardness as that of SC or ST, but as a class of post. Thereafter, it is clear that backwardness in relation to the class of post spoken would require to have a quantifiable data. And then he said that if there is a constitutional amendment which is held, if there is a decision of constitution, then judgment which has held a test of time, it need not be revisited. And now we come to the most important defense which was raised by Mr. Rajiv Dhawan. So essentially what he was saying forms the part of the judgment which eventually came from the Supreme Court. Now, Mr. Rajiv Dhawan, he said that Nagaraj has to be understood as a judgment, and read very carefully with me, which has upheld the constitutional amendments adding Articles 16(4)(a), 4(b) on the ground that they do not violate the basic structure of the Constitution. And he said that equality is the part of basic structure. So one of the basic structure brick is equality, right? Nagaraj applied 50% cutoff criteria, creamy layer, and no indefinite extension of reservation as facet of equality principle to uphold the said constitutional amendment. And he said, and for this reason, Nagaraj need not be revisited. So try to understand what he is saying. He says that Nagaraj, it has upheld the constitutional amendment of 16(4)(a), 4(b). He said that equality is the part of basic structure. He says that Nagaraj applied 50% of criterion, creamy layer, and no indefinite extension of reservation as facet of equality principle to uphold the same constitutional amendments, Nagaraj ought not to be revisited. Then coming on to the creamy layer, he said is a matter of applying equality principle as very important as unequals within in the same class are ought to be weeded out, and they cannot be treated as equal to the others. So when we talk about equality, it is very important that unequals within in the same class are to be weeded out, so that those, though they may be all belonging to say scheduled caste, right? But somebody has become a minister or somebody has become a Supreme Court judge, right? He cannot be at the same strata where they were earlier or other members of that class are. So in that case, you have to take them as creamy layer, so that the other, now they are not equal to them, they become unequals, and you cannot hold them to compete because they are getting the facilities, and hence they will be treated as they will be getting all the coveted posts. So the idea of reservation is, idea of affirmative action is to bring various components, to bring various members of that class at par with the unreserved category. So if some person attains that, he comes into creamy layer and he has to be weeded out. The whole basis of application of creamy layer principle is that those who are genuinely deserving of the reservation would otherwise not get the benefit of the reservation, and conversely, those who are undeserving, they will be getting the benefits. The creamy layer principle applies to exclude certain individuals from that class, and it does not deal with the group's rights at all. So you are not dealing with the group's right, but only with a certain individuals. So further, there was a lot of debate that you are altering the presidential list under the Article 341 and 342, and it is only the parliament who can do so. So what Mr. Rajiv Dhawan said was, there is no application of Articles 341 and 342 in this case. He said that 341 and 342 are not concerned with the reservation at all. What are they concerned with? They are only and only concerned with the identification of those who can be called scheduled caste and scheduled tribes. On the other hand, he said that creamy layer principle is applied by courts to exclude certain persons from the reservation made from within that class on the touchstone of Articles 14 and 16(1) of the Constitution. He argued that even if it is conceded that creamy layer can fall if it can be conceded that a creamy layer falls under Article 341 and 342, yet he said that the court has the power to enforce fundamental rights as part of the basic structure cannot be taken away. Very important. He said that what is the purpose of Article 341, 342? He says what is the purpose is to identify, to specify is the word that they have used in the Article 341 and 342. It is not concerned with reservation at all, right? This is what was the contention of Mr. Rajiv Dhawan. Further, he argued that even if it is conceded that creamy layer falls, assume that it falls under Article 341 and 342, yet the court's power to enforce fundamental rights as a part of basic structure cannot be taken away. So even if it creamy layer also forms under 341, 342, but you cannot take away the power of court to enforce fundamental rights as part of basic structure. And then he said that equality is the part of basic structure. You cannot treat unequals equals. Then he said Nagaraj was a case pertaining to constitutional amendment. Therefore, 341 and 342 cannot stand in way of applying the basic structure test to constitutional amendment. Now, I hope this much is clear. I think I'm exceeding my time, but nevertheless, I will just take 3-4 more slides to give you the ratio of the judgment. So the judgment said that Nagaraj does not need reconsideration by 7-judge bench. The judgment modified by Nagaraj with further backwardness. So in Nagaraj, Supreme Court had held that if the state chose to grant reservation in promotion, the state must collect. The state must choose to collect. If Nagaraj said that if the state choose to grant reservation in the promotion, state must collect quantifiable data to demonstrate the current backwardness of SC/ST been granting reservation in promotion. On further backwardness, the court held that the further backwardness condition is contrary to 9-judge bench judgment in Indraswani. So, current and further backwardness. Indraswani does not allow for collection of quantifiable data as prerequisite for granting the reservation. However, the court also added that the principle of creamy layer exclusions applies to SC/ST. Previously, creamy layer exclusion was applied only to OBCs in the matter of reservation. Creamy layer exclusion is a principle of equality. Very important, what this judgment has done, it is said that principles of creamy layer exclusion, it applies to SC and ST and not just to OBCs. Creamy layer exclusion is a principle of equality, and Justice Narayan held, the bench led by Justice Narayan held the exclusion, not led by Justice Narayan, this bench was led by Justice Divya Mishra. This judgment was penned by Justice Narayan, and he held that the exclusion of creamy layer principle is essential to safeguard the right to equality. It further held that failing to apply the exclusion of creamy layer principle would violate right to equality in 2 ways. And how? He said that firstly, it was held by doing so, it is treating equals differently, namely the general category people and the general classes and the forward among the backward classes. So he says that if you don't apply the creamy layer principle, the exclusion of creamy layer principle, then it is treating 2 equals differently, namely the general category and forward amongst the backward classes, that is SC/ST. Secondly, it held that by doing so, to treat 2 unequals the same, that is the backward class and forward among the backward class. Try to understand this. What is it doing? If you don't put SC/ST in the creamy layer, you just put only people from OBC into the creamy layer, but not SC/ST. What are you doing? By doing so, you are treating 2 equals differently. That is, those people of SC/ST who raise their standards and they have come at par with the general category, and general category people, you are discriminating. So you are treating 2 people who are equal differently. So this is of course a violation of right to equality guaranteed under Article 14. Secondly, you are treating 2 unequals the same. That is the backward class and the forward among the backward class. So if there is somebody who is a creamy layer, he has raised his standard, he has become a Supreme Court judge or he has become a minister, and those who are in the backward class, you are treating 2 persons differently. Very often the example which is given when you hear any arguments is that of Babu Jagjeevan Ram. He was the minister, and when he visited a temple, they had washed it because he belonging to the reserved class. They said that it has to be washed. So, I mean, that is just an anecdote that I gave you in between. But what judgment said that you cannot treat 2 equals differently, and you cannot treat 2 unequals the same. Then this applying the creamy layer principle to scheduled class and scheduled tribe, the court does not in any manner tinker with the presidential list under Article under Articles 341 and 342 of the Constitution. The court, it was speaking unanimously through Justice Narayan, held that caste and groups mentioned under presidential order is not altered, but those persons of the group who have come out of untouchability or backwardness by virtue of belonging to creamy layer are excluded from the benefit of reservation. And very specifically, Justice Narayan overrules the observation which is done in Ashok Thakur's matter, which deals with reservation in education, and it held, which was which came through, which was written by then Chief Justice K.G. Balakrishnan, that creamy layer principle is merely a principle of identification and not a principle of equality. Justice Narayan categorically overrules this observation. Then Supreme Court came on the second condition of state to give quantifiable data with respect to inadequate representation. The court held that this still stands. This was a good part of Nagaraj. But court further held that inadequacy of representation is to be in relation to the specific cadre and not to the SC/ST population in the state. B.K. Pavitra talks about of the group. Then again, Jarnail Singh speaking to Ellen Rao said about the cadre. In my opinion, cadre is the right thing. And these are just some judgments that I have written, noted down, which you might want to cover, which you might to read. So this is all from me. If you have any queries, please ask.
Thank you, Dr. Charu. Participants can unmute themselves and please ask the question. Thank you.
Hi, ma'am. This is Pallavi. How are you, ma'am?
I'm good. How are you?
Yes, good, ma'am. Thank you so much for this session today. So it was really good to hear from you once again, because we did not have any session for last 6 months, I think. Last it was December.
Yeah.
Ma'am, if you can just show us the last slide, because I couldn't, make notes of the last slide, the cases, just the cases.
Right, sure.
Yeah. Thank you, ma'am. Ma'am, also I wanted to know if you are going to do more sessions or this case law sessions. So, because I got this information in the AOR discussion group, if a mail can be sent to us or something, so that, we know whenever more sessions are coming, because since I'm not enrolled in the program anymore, so I don't get this information.
No problem. I'll send you if nobody else sends. But
Yes,
I'll ask people from ABC, they will be sending. It's not a problem.
All right, ma'am. Thank you so much, ma'am. And hopefully that our AOR exam will be either in December or maybe next June. I don't know. We are, because
Really
the results,
idea.
The results of the previous batch are still not out.
Yeah.
So we might just be shifted to June, I think. Let's see what happens.
No idea. No idea.
Yes, ma'am. Yes, ma'am. Yeah, ma'am. Yeah. Nothing as such. It was a very interesting case. And it was really nice to know about this entire reservation journey, because we keep wondering. I knew only a little bit, but today after hearing you, I think we have learned a lot. And once we go through the case, maybe we'll have more clarity on it.
Yeah, because I had limited, because when you talk about reservation and affirmative action, ideally I would like to start the journey from Pune back from 1932, coming down to Government of India. Like as you do service matters and education matters, which forms the last chunk of matters that come to Supreme Court. So
that's right.
These judgments become important.
That's right, ma'am. Okay, ma'am. Thank you so much, ma'am. That's all for me, ma'am. Yeah.
I think there are not any questions here. So we will just finish our session here complete. So thank you, Dr. Charu. Indeed, the session was very informative and was so elaborately explained, from the background to the explanation of related articles. This was indeed, I think, the most exhaustive discussion of this very important case. Now, I'm sure we have a lot of clarity now for all of us relating to this promotion case. Thank you once again, Dr. Charu, for this informative session. And thank you all the participants for joining. See you all again and have a nice weekend. Thank you so much.
Bye-bye.
Thank you.
Thank you, everyone. Thank you.
Thank you.